Hello, please turn to the review questions in your Law and Business Manual. If you've flipped through these pages, you can see they're all multiple choice questions. The state exam questions are multiple choice. And at the end of the test questions are the answers along with page references back to your manual. The pages include the information that the question's based on in case you want to do some review. Well, what I'm going to basically do here is take the test with you. We're going to go through the questions together. I'm going to make some comments. I'm going to review whatever is the relevant legal or business principle. I'll discuss exam strategy a little bit. I'll also be talking about possible variations of these questions in the state exam. So let's just get started here with question 1. Which of the following statements about advertising is correct? All right, now notice this is an all of the above question. D is all of the above. You may also see a question that says none of the above. So in this particular case, we have to agree that A, B, and C are correct answers before we can choose D. If any of them are incorrect, then D goes out the window. So let's start. A, an unlicensed contractor may advertise for jobs after submitting an application for a contractor's license. Does that sound right? No. A contractor's license has to be issued before you can advertise to do construction work, before you can bid construction work, before you can sign construction contracts, before you can perform those contracts. So it's not from the time you file the application, it's the time the license is issued. So that's not correct. So D's not going to be one of our answers. Let's go to B. Unlicensed contractors may advertise for jobs under $500 if the ads state they are unlicensed. Well, that's actually correct. Unlicensed contractors can do what's called minor work. That's work where the total contract price is under $500. You don't need a contractor's license for those types of projects. But be careful. If they're advertising, the ads have to state that they are unlicensed. So B is the correct answer. C says a licensed general engineering or building contractor may not advertise as a general contractor, and that would not be correct. If you have an A license or a B license, you can advertise as a general contractor. Question number 2, which of the following requires a contractor's license? Now, I want to warn you, this is one of the more difficult questions you're going to see in our course, and a lot of students miss this question the first time they try to answer it. So let's read it very carefully. A person who hires employees to build structures on his or her own property. So would they need a contractor's license? No, if they're building structures on their own property and they're using employees with wages as their sole compensation, they do not require a contractor's license. It's called the owner-builder exemption. So it's an exemption to the normal licensing requirement. So we would not choose A. B, a person who only installs satellite antenna systems on residences. They would not need a contractor's license because they're registered with the Bureau of Electronic and Appliance Repair, which is a separate state agency. C, a person who only installs electric fire alarm systems. Well, let's think about that one. They do need a contractor's license to do that. I know I was in a discussion with some students a while back, and they were trying to guess which classification was relevant. C16, the fire protection contractor, they should be able to do that. But actually, no, they can't. Fire alarm systems is an exception to that classification. Same with C7, your low voltage contractor. You would think they'd be able to install them, but no. Read their license classification. fire alarm systems are an exception. So who can install these things? Well, think C10, electrical contractor. That would be a license classifications that would cover this. But C isn't asking for the classification. It just wants to know if it requires a contractor's license. And that is the correct answer. It does. D, a person who only installs security alarm systems. No, again, you've got another state agency. They're licensed by the Bureau of Security and Investigative Services. So C is our correct answer. 3, a contractor must notify the registrar in writing of a change of business address within blank days. Okay. Now, you're going to get questions in our practice test and state exam asking about when to notify the registrar, how many days, maximum days. And usually it's 90 days. If you have to notify the registrar of something, you have 90 days to do it. There are exceptions. We'll see an exception when we talk about appealing a citation issued by the registrar. But in general, if you're taking the state exam and you just draw a blank, but it has to do with notifying the registrar, 90 days would be a good guess. So how do you notify them? You just, you can go to the website and you can download a PDF of their form, and you fill it out and you send it in with a fee. Most of these things have a fee attached, and so you take care of it, but you have 90 days. It's really important that you remember to do that, okay? Some people forget, and if they don't have your current address and they want to send you a renewal notice for your license, for example, it could be returned to them. So they're going to know you didn't comply with the law. Plus, you may not get your renewal notice in time, and your license may expire. And if your license expires, then you can't do work as a contractor. Hopefully, you're not in the middle of a job, so be really careful about that. Question 4, a contractor may renew an expired license up to blank years from the date it expired. So the license is expired, and now they want to renew it. Now, this is one area where I think the law is pretty generous, because you have up to 5 years. 5 years, that's answer C. You'll have to pay a delinquency fee, but you won't have to file a new original application and take the exams. You just pay a delinquency fee. So the answer is 5 years. Question 5, an active contractor's license must be renewed every 2 years. It has to be renewed every 2 years. An inactive contractor's license, and this is another question you could be asked in the state exam, what would be the renewal requirement in terms of years? And the answer is every 4 years. So an inactive license is on hold. You can't contract, and it's renewed every 4 years. Active license, every 2 years. A. 6, which of the following is not true of an inactive license? Okay. A, an inactive license must be renewed every 4 years. Well, that's true. We just covered that. B, inactivating a license will not prevent disciplinary action against the contractor. Well, that's also true. If you've been cited, or if there's a disciplinary proceeding, you can't simply inactivate your license to avoid having it suspended or revoked. C, you may not practice as a contractor until the license has been reactivated. That's also true. Your license is inactive, it's on hold. D, this should be the answer we want, it's the last one. An inactive license requires a contractor's bond. No, it does not. If your license is on hold, you do not need a contractor's bond. You do not need a workers' compensation policy. And if you had an RME, a responsible managing employee, or if you're a corporation and you had a responsible managing officer, they do not have to be employed. You can let them go. And because, again, you're not practicing as a contractor. Your license is inactive. So D is the correct answer. 7, which of the following is not a cause for disciplinary action by the registrar? A, abandonment of a job without lawful excuse. Well, that is very definitely a cause for disciplinary action by the contractor. When the board was set up originally, years and years ago, they only listed 4 possible causes of disciplinary action, and this was at the top of the list. They're very concerned about that. B, not paying subcontractors immediately upon receipt of a progress payment. So is that a cause for disciplinary action? No, it would not be a cause because the direct contractor, the prime contractor, has 7 days. So if the subcontractors are paid within 7 days of the receipt of a progress payment, then they're in compliance. There would be no disciplinary action. So B would be our answer here because it says immediately. Diversion of funds, materials. D, willful departure from or disregard of plans and specs. Those are definitely causes of disciplinary action. Let's go to question 8. How many working days does a contractor have to appeal a citation from the registrar? Now, remember I said notices to the registrar usually involve 90 days. That's the maximum time. Here we're talking about a citation. So the contractor has been issued a citation by the registrar, and the contractor wants to appeal the citation. They want a hearing. And what they're saying here is that you have a maximum of, and the answer is 15 working days. Be sure to, if you get a citation and you want to appeal it, be sure to get your appeal in on time because you don't want the registrar's order to become final. Question 9. Which fees are not paid for by the registrar in a CSOB arbitration? Okay, so the CSOB offers voluntary and mandatory arbitration programs. And who pays the fees? For example, you're going to have an arbitrator. Does the CSOB pay the fee, or does the contractor pay the fee, or for that matter, does the consumer, who's the other party in the arbitration, pay the fee? Well, let's go through them. The arbitrator's fee, A, is paid for by the registrar. Administration fees, those are paid for by the registrar. Expert witness fee, paid for by the registrar as long as there's only one expert witness. If you want to bring additional witnesses, you have to pay for them. But C is okay because it just mentions an expert witness fee. D, attorney's fees. Okay, so the registrar is not going to pay your attorney's fees. They're not going to pay the attorney's fees of the consumer who brought the complaint. So D is our answer. Number 10, the underground service alert color code for a sewer line is, and I think a lot of you know this answer just from your work experience, it's green. We do have a chart in Chapter 1 that lists the color codes for underground service lines. You might want to review that. B, blue would be a water line. Purple would be reclaimed water. Orange would be communications. And but in this particular case, the answer is green. Okay, let's move over to the questions under Chapter 2. We're at question 11. A contractor must notify the CSOB in writing within how many days from the time a registered home improvement salesperson ceases to be employed, okay? We're notifying the CSOB, or the exam question may be the registrar, but it's 90 days. As I mentioned before, that's a common statute. Let's go to question 12. Question 12. A contractor and owner agree to a price of $35,800 for a home improvement contract and sign a contract. What is the maximum down payment that the contractor may require before starting work? Okay, let's review the law on that. For home improvement contracts, the down payment can be $1,000 or 10%, whichever is less. So that's the maximum. So here, it's $35,800. 10% of that would be $3,580, but $1,000 is the lesser of the two, and that's what the law says. So the answer here would be B, $1,000. Question 13, home improvement contracts must include all of the following except the name, address, and license number of the contractor, that's required. A statement that the contractor has a workers' comp policy or is exempt, required. Exact dates when work will begin and be completed. No, that's not correct. It would be the approximate dates, not the exact dates. And D is mechanics lien warning, and of course that's required. Question 14, a joint control is primarily a third-party management of. Well, a joint control company is an escrow agent, basically responsible for the distribution of construction funds. So what we're looking for here is construction funds, and that's answer D. 15, if a contractor's bilingual salesperson makes a presentation to a customer in Spanish, the home solicitation contract. All right, so the rule is that the contract must be in the same language as the sales presentation. So the question says the presentation is in Spanish, so we're looking for must be in Spanish, and that's answer C. Let's go to question 16. The maximum time an owner has to cancel a home solicitation contract is, well, we're looking for 3 because the owner has the 3-day right to cancel. C mentions until midnight of the 3rd business day after the day the contract was signed. So that's the correct answer. Now remember that the owner has to receive a signed copy of the contract and the 3-day right to cancel notice. You can't argue that, well, they didn't have that right. If, in fact, you did not give him the notice, you did not give him a signed and dated copy of the contract. But anyway, that's just an aside. C is the correct answer. 17, how many days does a contractor have to refund any payments from the date that a home solicitation contract is canceled? The contract is canceled, you have 10 days to return any payments. 18, the contract price of a service and repair contract may not exceed, well, the maximum is $750, so A is the answer. Now be careful, in the state exam, they may change the question. The important thing to remember, aside from the maximum of $750, that no payment is due until the work is completed. That's important, and so you may see that as a possible question answer in the state exam. 19, for the majority of construction defects, what is the maximum time a homeowner has to file a lawsuit after the original close of escrow? So they're just talking about the majority of construction defects, and the statute of limitations would be 10 years. That's the answer they're looking for. Now, there are exceptions. For example, if the issues have to do with paint, stain, then the statute can be shorter. It could be 5 years. But here they're just talking about the majority. So let's go to question number 20. On a public works project, if the subcontractor's percentage of the total bid exceeds blank, the prime contractor must include the subcontractor's name and address in the bid. Okay, so that's dealing with the Subletting and Subcontracting Fair Practices Act. And the answer here is, the way they've expressed it, is 0.5%. The law states 0.5%, so 0.5% would be our answer choice here, A. Okay. So now let's go to Chapter 3, Mechanics Lien Law questions. 21, on private works, a preliminary notice must be served within how many days from the time a claimant first performed work or supplied materials? The answer is 20 days. It used to be called a 20-day preliminary notice. Then the legislature kind of overhauled the mechanics lien law. Now they call it a preliminary notice. But in either case, the answer is 20 days, answer B. Now, what about a late notice? A late notice is still valid. It just doesn't cover your work back to the beginning. For example, if you started working on September 1st and you don't file a preliminary notice until the end of the month, September 30, it's not going to cover the first week's work that you did, so just be aware of that. So late notice is okay, but it's just limiting the time that's covered. Number 22, a subcontractor must give a private work preliminary notice to the, well, we're talking about a subcontractor, so the preliminary notice must be given to the direct contractor, sometimes called the prime contractor, the property owner, the lender. So the answer here is D, all of the above. Number 23, a material supplier's mechanics lien must be filed with the, well, all liens, whether it's the prime contractor, subcontractor, material supplier, they have to be filed with the county recorder's office. That's why you hear the phrase recording the mechanics lien. And I might add, it's the office in the county where the property is located. Now, in the state exam, they may ask a question about that. So it's in the county where the property is located. Okay. Number 24. A homeowner may release the property from a lien by recording A. So a lien's been recorded against the property. So what can the homeowner do? A says notice of non-responsibility. Well, that wouldn't do the homeowner any good because the lien's already been recorded. A notice of non-responsibility, as you probably remember, is posted and recorded within 10 days after the owner first learned that work is being done in their property that they haven't authorized. But the lien is filed, so that's not going to help them. B, a bond in the amount of the lien? No. The answer is C. The bond must be equal to 1 1/4 or 125% the amount of the lien. Now, some people say, well, you know, what's the good of recording a lien if the property owner can just bond around the lien? Well, if you think about it, a bond, which is backed by a big insurance company, if you get a judgment, is going to be a lot easier to collect on than a property that, may have other debts, other claims against it. So bonding around the lien is fine by me. But the bond has to be 1 1/4 times. Question 25, which of the following may not file a stop payment notice in Public Works? A, the direct contractor, subcontractor, material supplier, surveyor. Well, in this particular case, the direct contractor may not file a stop payment notice because they're referring to Public Works. Now, if they're not paid by the public agency, they would file a breach of contract lawsuit. What about private works? What if the state exam mentions a private work? Well, the direct contractor can file a stop payment notice if there is a construction lender, but that's a private work. This question is talking about public work. So A would be the correct answer here. Number 26, the minimum bond required for a stop payment notice in the amount of $50,000 is, well, it's the same as for a mechanics lien, 1 1/4 times or 125%. In this case, the amount of the stop notice. So it's 50,000. What is 1 1/4 times 50,000? It's going to be 62,500, answer B, because 12,500 added to 50,000 would give you 62,500. Some of you can do the math in your head. Another way to do it is just take 50,000 and multiply it by 1.25, and you'll get your answer. Be careful with math. Okay, you want to, when you're taking the examination, always double check your math. 27. How many days do subcontractors have to record their liens after a notice of cessation is recorded? Well, these are subcontractors, and a notice of cessation is recorded. A notice of completion could be recorded, the same result. Subcontractors are limited to 30 days. So they have 30 days to record their liens. Now, if no notice of cessation or completion are recorded, then all the claimants, including the subcontractors, have 90 days. But that's not the case here. Here they have 30 days. Number 28, how many days does the direct contractor have to record a lien after notice of completion is recorded? Okay, the last question was notice of cessation. Well, we're talking about the direct contractor, and the state exam may use the word prime contractor. But in the case of the direct contractor, they would have 60 days, B, after a notice of completion, or I'll add a notice of cessation happens to be recorded. 29, a lease pendens notice must be recorded within how many days after filing a lien foreclosure lawsuit? So a lawsuit's been filed. Now, lease pendens is often translated, it's a Latin expression, it's often translated dispute pending. It's just considered fair notice that a foreclosure lawsuit has been filed against the property. So anybody that happens to be considering maybe buying the property can look in the public record and see there's a lawsuit. Now, one other thing I want to add, and this could be an exam question, when a mechanic's lien is recorded, it expires after 90 days. So you have to remember that. Just recording the lien, it just doesn't stay there forever. It expires after 90 days unless a lawsuit is filed. So that's another potential question that the state could ask you. But here, they want to know about the lease pendens, and the answer is 20 days. It has to be recorded within 20 days after filing a lien foreclosure lawsuit. Number 30, a lien foreclosure lawsuit must be brought to trial within how many years after recording the lien? So now we're talking about bringing it to trial. And the law puts a limit. The property can't be tied up forever. And the answer is 2 years, B. Okay, now we're going over to Chapter 4, questions, hiring employees. This will cover labor code requirements, basically. Number 31, which of the following may a private employer require of a job applicant or an employee? A polygraph test, so that's a lie detector test, and that may not be required by a private employer. B, information on a previous arrest that did not lead to a conviction. They may not ask information about that. C, a photograph of the employee that will be paid for by the employer. That's okay. A lot of times they use photographs for IDs or badges that the employees will wear. So C is correct. D, none of the above. We're not going to select that because we've got a correct answer here in C. All right, let's look at go on to question 32. Employees must complete Section 1 of Form I-9. And I-9, if you recall, is the employment eligibility verification. And there's a section, the first section, where the employee fills in their name, address, and that type of information. And it also, there's also a box where they check under penalty of perjury what their status is. For example, if they're a citizen of the United States or if they're a non-citizen national of the United States. So that's information in Section 1 that is supplied by the employee. However, it's really important to understand is you never ask the potential employee, we'll call him the prospect, to fill out that information before they have accepted a job offer until they're hired, okay? Now, the question here says, when's the latest? And it would be A, no later than their first day of employment. And that's the rule there. Notice D, it says before they accept a job offer. No, absolutely not. So A is the correct answer. 33, personnel records for an employee must be kept for a minimum of how many years after he or she is terminated. Well, the minimum is 3 years, D. You can keep them longer, but you have to keep them for at least 3 years. An employee can ask to review their records. This could be a state exam questions. If they give 30 days written notice to you, then the employer has to allow them to review those records within 30 days of that written request. So bear that in mind. But here, the answer is 3 years. 34, a successor clause for a collective bargaining agreements is limited to, well, a collective bargaining agreement would be between an employer and a union. And what they're getting at here is how long, what's the duration? Well, a successor clause means that someone comes along and buys the business from the original owner. And what they're getting at here is that the new owner has to comply with the collective bargaining agreement that the previous owner agreed to. But the question is how long? How long do they have to do that? And the Labor Code limits successor clauses to 3 years. So the answer is D, 3 years. 35, an employee who quits without notice must be paid, and the answer is B, within 72 hours. If they're terminated, they have to be paid when? Immediately, okay? If they give 72 hours notice, this is advance notice, that they're going to quit, then you have to pay them at the time they quit. So those are the basic payment rules. Let's go on now to question 36. IRS Form 941 for the second calendar quarter must be filed by, and then they give the dates. Okay, so we're talking about 941, the employer's quarterly federal tax return. And the rule here is that the return for a calendar quarter has to be filed during the month immediately following the end of the quarter. So what's the second calendar quarter? The first is January, February, March. The second is April, May, June. Which month immediately follows June? July, of course. And so let's take a look at the answer. C would be the correct answer. July 31st would be the deadline. They can file at any time during July, but they can't file it any later than the 31st of July. Okay. Question 37. Which of the following payroll taxes is withheld from employee wages? So what can you withhold from an employee's wages? A is FUTA, the federal employment taxes. B is the ETT, the training tax. You've got state unemployment taxes, C. The employer cannot withhold those from the employee wages. So we're left with D, state disability insurance, SDI, that is withheld from the employee's wages, along with any PIT, personal income tax, that the employee may have earned. But anything having to do with training or unemployment is not deducted. So D is the correct answer here. Number 38, a licensed contractor who purchases a workers' compensation policy must report the insurer's name and address to the registrar within how many days after the policy is issued? Well, what did I say was the common statute for notifying things to the registrar? In general, it's 90 days, so C is the answer here. 39, an employer is required to record employee injuries and illnesses on Cal OSHA Form 300 if they have more than how many employees? Okay, so Form 300 is a log of work-related injuries and illnesses. And the law is A. If you have 11 or more employees, then you have to record the injuries and illnesses on Form 300. That's the answer they're looking for there. Let's go to question 40. A contractor working with asbestos-containing materials must register with DOSH if the surface area in square feet is, the answer is 100. I think you already know that, but if you don't, memorize that. 100, that's a very important number. So you have to register with DOSH. You register specifically with the Asbestos Contractors Registration Unit. You can notify them, and they'll give you a registration packet. But let me tell you, if you're working with asbestos, you want to meet the requirements, because you can get in a lot of trouble if you don't. Let's go to Chapter 5. Now we're into business management. Which of the following types of business organization is associated with double taxation? Well, C. It says C corporation. C corp is just a regular corp. When people say a corporation, they're usually referring to a C corp. Yes, C corps are known for double taxation. The reason for that is that the corporation, the income earned by the corporation is taxed, and then the owner or the shareholders are taxed separately for any salary, bonus, or dividends that they take. So there is double taxation, and that's one of the drawbacks of a C or regular corporation. So C is the correct answer. S corporations are actually what are called pass-through businesses. So the income passes through to the owner, and the owner just pays one tax, and they avoid the double taxation. Question 42. Which of the following insurance policies will increase the coverage limits and expands coverage of a commercial general liability policy? So let's say you have a CGL, as it's sometimes referred to, commercial general liability policy with a limit of $1 million. And you're going to be taking on some new jobs, some bigger jobs, and you don't know if that's high enough. So what you can do is get an umbrella policy, that's selection B, because with the umbrella policy, you can increase the limits. Let's say you think, gee, I need a limit of $2 million for this type of work. That's what the umbrella policy would provide. It can also expand coverage. For example, if your commercial general liability policy doesn't cover work done at night and you want that work covered, you can get that covered under an umbrella. So B is the correct answer. Question 43. The type of insurance that covers claims made after the policy expires or is canceled is, A says claims made, and that's not correct. Both the incident and the claim have to be within the policy period. That's how a claims made policy works. B, occurrence, that would be the correct answer, answer B, because it's when the incident occurs. Think of occurs. Even if the policy has expired, claims can still be made. So again, occurrence focuses on when did the incident occur. Did it occur within the policy period? B is our answer. Let's go to question 44. In the cash system of accounting, a transaction is recorded or posted. So we're talking about cash basis or cash system. And just the principle here is that you don't consider something income unless payment is actually received. You receive cash. You can receive a check or electronic transfer, of course, but they're using the term cash in a generic sense. And also expenses are not considered expenses until they're actually paid, okay? So with that in mind, if you go through answers A, B, C, when a bill is approved for payment, well, that's not cash payment. It hasn't been paid. When an invoice is mailed, well, it's not cash basis because payment has not been received. When income is earned and expenses are incurred, no. What are those three? They're all accrual. They all refer to the accrual basis or the accrual system of accounting. D, when cash changes hands. Well, that's kind of a brief statement, but it's true. That's really what it amounts to. When you give someone cash or they give you cash, that's when the transaction would be posted as income or expense under the cash basis of accounting. So D is the correct answer. 45, which of the following is not a current asset? So we're talking about a balance sheet. You can spot C right away, bank loan. A bank loan is not an asset, it's a liability. So that's not a current asset. That'd be the correct answer. Retentions, prepaid expenses, inventory are all current assets. 46, what is the difference between a balance sheet and an income statement? A balance sheet is a summary at one particular point in time, where an income statement is a summary over a period of time. That's true. A balance sheet has often been likened to a snapshot of your business at a particular instant. So it's what assets you had, what liabilities you had, and what your net worth was today, for example. So it is a summary at a particular point in time. And an income statement is a summary over a period of time. So you'll see an income statement. It might be monthly, it might be quarterly, it may be annual, but it covers a period of time. It isn't a snapshot like a balance sheet. So A is the correct answer. B, C, D, it says that the balance sheet is prepared annually and covers a fiscal year. No, a balance sheet can cover a fiscal or a calendar year. And it could be prepared annually, but you certainly wouldn't want that. Any of your financial statements, balance sheet, income statements, should be prepared frequently so you can look at the health of your business. Let's go to question 47. Working capital is A, different from operating capital. Well, that's not correct because they're the same thing. Working capital is operating capital is working capital. They're just different names for the same thing. B, the difference between liabilities and owner's equity, no. Total income minus total expenses, no. D is the correct answer. Working capital is total current assets minus total current liabilities. D. Let's go to the next question, number 48. We're making progress here. So far, did you know all the answers before I selected them? If you did, I'm impressed. 48. The bottom line, quote unquote, of an income statement is, okay, I mean, that's an expression we've heard many, many times in the business context. It's net profit. D. The whole idea of a business is to make a profit. And if you're running chronic losses, then you're going to have to fix the problem or just close down the business. So it is the bottom line. That's what you're looking at. All of the other numbers are important. You want to see where you can improve, for example, reduce expenses, that type of thing. But the bottom line is, are you making a profit or are you not making a profit? D is the answer. 49. What would be the net profit if income is $100,000, cost of sales is $55,000, gross margin, which is otherwise known as gross profit, is $45,000, and expenses are $35,000. So there's a lot of numbers here. Let's just remember how to calculate net profit. It's the income less the cost of sales, which gives us the gross margin or gross profit. And once you get the gross margin, you subtract the expenses and you've got net profit. Okay? Now, here we can take a shortcut. You don't have to calculate 100,000 minus 55,000, et cetera, because they give us a gross margin. It's 45,000. So what you can do here is simply take 45,000 and subtract the expenses of 35,000, and that leaves you 10,000, which would be your net profit. Sometimes I think the state throws in a lot of numbers just to see who really understands the formula, the calculation. But here, the numbers are helpful because they give you the gross margin, which is what you really need in this particular case. Question 50. Cost of sales on an income statement would not include, okay, they have salaries, Oh, no, not under cost of sales. Salaries is an item of overhead expense. So if you have someone working in the office, part-time or full-time on a salary, that would be charged against expenses, not cost of sales. Cost of sales, remember, are direct costs that are directly chargeable to individual jobs. So materials is an example of that. So B, C, D would all be direct costs, but not A. A is the answer. 51, the current ratio is also known as the acid test. No, that would be the what? The acid test is the quick ratio. B, the ratio of quick assets to current liabilities. No, quick assets to current liabilities would be the quick ratio. That's the formula. C, the ratio of current assets to current liabilities. That's it. That's what the current ratio is. So C would be our answer. D, ratio of inventories to prepaid expenses. No. Answer C is the correct answer. All right, let's go to number 52. And which of the following statements is correct regarding the quick ratio? A, it considers only assets that can be quickly converted to cash. Yes, that's pretty much the quick and the quick ratio. B, it excludes inventories. It does in the basic formula. C, it is more conservative than the current ratio. Yes, because it excludes inventories. So in this case, we agree with A, B, C, so we're going to go with D. All of the above is the correct answer. 53. What is the quick ratio of a company if current assets are $80,000, current liabilities are $40,000, inventories are $30,000, and net profit is $12,000? Okay, they want to know the quick ratio. We know the formula. Does net profit have anything to do with the quick ratio formula? No. So they've thrown in a number here just to throw us off, just to see who's guessing. All right, let's go back. The quick ratio is the quick assets over the current liabilities. How do you get the quick ratio? Well, the quick ratio are the current assets minus inventory. So let's go in here. We've got current assets of $80,000. We subtract inventories of $30,000, and that gives us the quick ratio of $50,000. We have quick assets. Now we go to the quick ratio formula, and it's $50,000 over the current liabilities of $40,000. Now you don't express the quick ratio as a fraction. You convert it, and if you divide 40,000 into 50,000, you get 1.25, and that is answer C. Let me mention one thing here. You have to read these questions carefully because sometimes the state will throw in a multiple choice answer that you would calculate if you didn't know the difference between the current and the quick ratio. For example, if you use the current ratio formula by mistake, you didn't use quick assets, you could end up thinking that, well, maybe D is the correct answer. It's 2.00. Maybe that's the correct answer. But it's not. If you use the quick ratio formula, the correct answer is 1.25. Question 54. A budget is or should be a tool for providing control. Well, yeah, that's the basic idea of a budget. Because, when you set up a budget, you want to detail exactly how much is going to go for advertising, how much is going to go for rent, how much is going to go for any number of things. In the manual, there's an example of a budget that lists all types of items that are accounted for. So the idea is to control costs. You've heard people going over budget or under budget, and they're talking about cost. So A is correct. This is an all the above, so let's keep reading. A detailed plan of future receipts and expenditures. That's true, because a budget is a forecast. You're basically setting a budget for a month or longer, and It's a plan. You don't know what they're going to be ultimately. You may be wrong. Some costs may be higher than you thought. They may exceed budget, but you have to start with a plan. C, reviewed monthly and updated if needed. Well, that's absolutely true. You don't set a budget on January 1st and then check it on December 31st. You have to constantly look at the budget to see if you're meeting expenses, and if you're not, you have to make some corrections. So D here, all of the above is the correct answer. 55, the total financial resources made available to an owner of a company are called, and, well, capitalization is what they're getting to here. By the way, I just wanted to remind you, the chapters have glossaries where they define different terms. This is one of the terms that's defined, I think, in the Chapter 5 glossary. It's really important to go through those glossaries as part of your exam prep, because you might run into a term in an exam that you don't know, and so you really don't know how to answer the question. If you do know the definition or what the term means, then it'll make it a lot easier. So be sure to just go through the glossaries. If there's any terms you don't know, mark them, look at them again just before you take your state exam so that they're fresh in your mind. Now, the reality is, of course, that when it comes to capitalization, it's really a term that falls under different categories. If you ask an economist, an accountant, a financial analyst, they may all give you different definitions. But in the state exam, we're talking about its simplest application, and that capital means money, and capitalization is getting money for the business. So you're starting out, you formed a corporation that has a contractor's license, but you don't have a lot of money, so you look for investors and you sell them stock. And of course, their hope is that the business will prosper, so the value of their stock will increase, and they'll also get dividends. Okay, so they provide capital to the business. They provide money to the business. All right, let's go to number 56. We're in Chapter 6, Operations Management. Which of these scheduling techniques is relatively simple and graphically shows the starting and finishing times for individual tasks that make up a job? Okay, so it's simple and shows the starting and finishing times. And that would be simply the bar chart, C. Sometimes you'll see the Gantt charts, G-A-N-T-T, but in construction, it's usually referred to as the bar chart. So it's just a method of project management. C is the answer. 57, how often should a contractor visit a job site to schedule deliveries, resolve conflicts, and coordinate the work of subcontractors? Well, the first answer, A, is daily. You better pick daily if you get that a question like this in the state exam, because the various publications and brochures that are put out by the Contractor State License Board stress the importance of checking in on a job on a daily basis. Now, anything can happen during a particular day. A truck can break down, an employee doesn't show up, and also you have to be very careful that any safety procedures are being followed. You want to make sure that work's being done according to code. If subcontractors are arguing with one another or with one of your supervisors, you've got to get out and mediate that dispute. On bigger jobs, sometimes the contractor will just have a trailer there, kind of a makeshift office with either the contractors or supervisor there to make things, sure things go smoothly. So daily is the correct answer here. 58, which type of surety bond guarantees that the contractor will perform the contract in accordance with its terms and conditions? Okay, perform is the key word here. A license bond, that has nothing to do with performance of a contract according to terms and conditions. It's the performance bond, B. That's what you would get to provide that type of coverage. And, it's required. A private owner's public works will require a performance bond. You can also be required to do a payment bond, but that has to do with paying subcontractors and others who are due payment for work they've performed. A bid, of course, a bid bond would be, again, on a public works project. They have an involved bidding procedure, and so if you bid and they award you the bid, they want to make sure you will sign the contract, because if you don't, then they have to go through this whole procedure again. So it's a performance bond. So the bonding company basically will do one of two things. If you don't complete a job, they'll either hire another contractor to come in and complete the work, or they will just write the owner a check to compensate them for any losses. 59, which is usually the most difficult item to estimate? Well, this is actually a very old question, and the answer is labor. B, materials are relatively to estimate for a job. Permits, equipment, rental, they're all, certainly compared to labor, much easier to estimate. So the answer here that they're looking for is A. Let's go to the final question, number 60. So do you think the final question will be an easy question since we've been struggling through all these questions, or do you think they're going to make it difficult? Let's see. How much is a 5% retention in dollars if the total job price is $185,000 and the company overhead is $37,000? Well, if you understand the formula, this is a very easy question. Okay, so the retention is the amount of money retained by the, if it's a private work, the owner, and usually they hold back the money until the lien periods expire because they want to make sure there's not going to be claims on their property. So it's a 5% retention. The total job price is $185,000. So the answer is simply $185,000 times, if you're punching this into a calculator, 0.05, the decimal equivalent of 5%. And that gives you the answer of $9,250. Okay. Now again, when you read a question, you want to think of the basic formula. Just because there are extra numbers there doesn't mean that they apply to this particular problem. Now, someone who wasn't thinking, if they were, for example, to take $185,000 and subtract the overhead of $37,000, which would give you $148,000, and then take 0.05, you would get $7,400. And look, it's one of the answers. So if they were being sloppy, they could pick the wrong answer, and of course they missed the question. But again, when you see a lot of numbers, first ask yourself, what is the formula? What numbers do I need to plug into the formula? And if you do that, then you won't get trapped by the states throwing in numbers that are irrelevant. Okay, so we've been through the 60 questions of this particular review. We've got hundreds and hundreds of more practice questions for you to work at. So we're going to be approaching all of the information in your manual from every angle imaginable. So please take the time to go through the practice test and go back to the manual if you need to review anything, contractor's license law, mechanics lien law, business management, whatever. And if you do all that, you're going to be prepared for the state exam. Okay. Well, I wish you the best on the state exam, and thank you for listening.